Hi there, I'm Jenna Layton, your Vice President of Legislation for San Diego SHRM, and I'm back with another legal update. Don't forget to check back every month as I'll be bringing you the most current information you need to know in order to be up to date on the legal issues that are affecting California's employers. This month I'd like to talk to you about two cases. The first case is called Kirby versus Emos Fire Protection. In this seminal decision, the California Supreme Court ruled that the California Labor Code does not permit an attorney's fee award to a prevailing party on claims for meal and rest break violations. This ruling comes on the heels of the court's decision in Brinker, wherein it confirmed that employers need only ensure that employees are provided an opportunity to take their meal periods, not to ensure that such breaks are actually taken. In this case, the plaintiffs sued Emos Fire Protection and several other defendants for alleged violations of various labor laws. The amended complaint stated 7 claims, the 6th of which alleged that Emos failed to provide its employees rest breaks, as required by California Labor Code Section 226.7. The plaintiffs ultimately dismissed this claim as to Emos after reaching a settlement with other defendants, and Emos subsequently moved for attorney's fees. While the trial court awarded these fees and the appellate court affirmed the decision, the California Supreme Court reversed, holding that the relevant portions of the California Labor Code do not authorize an award of attorney's fees to a party that prevails on a Section 226.7 claim. Kirby is a positive decision for California's employers and may reduce the number of class action lawsuits brought for alleged violations of meal and rest break laws. However, the court's ruling does not prevent plaintiffs from recovering attorney's fees when they successfully litigate other wage and hour claims. The second case I'd like to talk to you about is Samaniego versus Empire Today LLC, which is the latest in an onslaught of decisions from California courts invalidating allegedly unconscionable employment arbitration agreements. In this case, the plaintiffs worked as carpet installers. When they were initially hired, and again later during their employment, the plaintiffs were given form contracts and told to sign them if they wanted to work for Empire Today. Both contracts were presented only in English, although the plaintiffs could not read English fluently. The contracts were offered on a non-negotiable take-it-or-leave-it basis, with little or no time for review, and consisted of 11 single-spaced pages of small font riddled with complex legal terminology. Within the contract was an arbitration agreement, which shortened the statute of limitations for claims and included a unilateral fee-shifting provision that required the plaintiffs to pay any attorney's fees Empire might incur to enforce its rights under the contract. Additionally, although the contract dictated that arbitration would be governed by the commercial rules of the American Arbitration Association, those rules were not provided to the plaintiffs. Both the trial court and the appellate court found the arbitration agreement to be both procedurally and substantively unconscionable. Procedural unconscionability arose from the fact that the agreement was offered on a take-it-or-leave-it basis in a language the plaintiffs were not able to read sufficiently well. Although the plaintiffs asked for a Spanish translation of the agreement, the request was denied. Moreover, the plaintiffs were not provided a copy of the agreement or a copy of the relevant arbitration rules. The court found that procedural unconscionability was also inherent in the presentation of the agreement, which consisted of 11 pages of densely worded single-spaced text which required no separate acknowledgement by the plaintiffs. Substantive unconscionability arose, according to the court, in part from the fact that the agreement unilaterally shortened the limitations period to 6 months, required the plaintiffs to pay any attorney's fees incurred by Empire, but imposed no reciprocal obligations on Empire. Like many recent cases with similar holdings, this case serves as an important reminder to employers to review their arbitration agreements and eliminate provisions which may be considered to be unconscionable and therefore unenforceable. For more information on these and other hot legal topics, check out San Diego SHRM's newsletter, The Resource, at www.sdshrm.org. Additionally, I invite all of you to join San Diego SHRM's Legislation Committee, where you'll have an opportunity to impact the lawmaking process and the legislative decisions that affect you and your business. For more information about this exciting opportunity, please contact me at 858-509-5696. You can also contact me via email at jlayton@petitcone.com. That's JLEYTON at pettitkohn.com. That's all for this month's legal update. I'll be back next month with more of the information that you need to know.